When do you need to hire a tax attorney? I'm Andrew Bosserman, and I'm a former IRS agent and a current tax controversy attorney who spent years helping CPAs and business owners navigate challenging tax situations. Today in this video, I want to address a question I get quite frequently, which is when should I bring in a tax attorney? Whether you're a CPA advising clients or a business owner dealing with tax issues directly, knowing when to escalate your case to legal counsel can mean the difference between a manageable situation and a financial disaster. So let's dive in and learn more. First, I want to emphasize one point. CPAs are absolutely essential. They handle tax preparation, planning, compliance, and oftentimes a lot more. But there's a critical distinction between tax compliance and tax controversy. So here's the difference. When you're filing returns or doing quarterly estimates or planning tax strategies, that's called compliance work. But the moment you receive certain letters from the IRS, face potential penalties, or deal with allegations of criminal wrongdoing, you've crossed into controversy territory, and that's where a tax attorney can provide great value, especially one that focuses on tax controversy matters with the IRS. So when should you exactly pick up the phone and call a tax attorney? Let me walk you through some major red flags that should cause you to reach out to a tax attorney. So first, fraud penalties or substantial understatement penalties. If the IRS is asserting fraud penalties or substantial understatement penalties, you should reach out to legal representation, especially for fraud penalties, because these are 75% of the underpayment and require proof that you intentionally disregarded your tax obligations. So these allegations have serious implications, and a 75% penalty is large, and a fraud situation may require the protection of attorney-client privilege. So it's extremely important that you bring in a tax attorney. Second, if you have any offshore account issues or other international tax issues. So unreported foreign bank accounts, FBAR, that stands for Foreign Bank Account Report violations, or foreign income reporting issues, these are very serious. The IRS goes after international tax issues regularly. The penalties can be staggering. They can be up to 50% of the account value per year for willful FBAR violations. So whether you're just now coming into compliance or responding to an examination, definitely get an attorney involved early. Third, if you've received a summons or an information document request from the IRS. So when the IRS issues a summons, especially a third-party summons, say to another individual or business associate, you need legal advice. Similarly, if you receive an information document request, this is also known as an IDR, that seems to be fishing for information about your intent or asking questions that go beyond typical audit inquiries, bring in counsel. As a former IRS agent, I've seen summonses and information document requests and generally know what the IRS is fishing for or trying to get when they request documentation. A tax attorney like me can advise on whether or not this is a standard request or if there's potentially something more serious at issue. The fourth red flag is employment tax issues. So if you're a business owner and you don't pay your payroll taxes, you can be assessed what's called the trust fund recovery penalty. And what this penalty does is it holds individuals personally responsible for unpaid payroll taxes. So if you're a business owner and you had responsibility, or even if you weren't an owner, but you still signed checks or had some sort of decisions about payroll or paying other creditors, you could personally be on the hook for unpaid payroll taxes. The IRS can be aggressive about these penalties, and you definitely need someone who can represent you, negotiate, and if possibly litigate the issue in tax court. The fifth red flag is refund litigation. If you filed a claim for refund from the IRS and they've denied it, or the statute of limitations is about to expire and you need to protect your claim, you may need to file suit in federal court. So whether it's district court or the Court of Federal Claims, refund litigation requires an attorney who understands both tax law and federal litigation procedure. And because this is a lawsuit you file in court, a CPA or an enrolled agent can't represent you. You need an attorney. The sixth red flag is appeals or tax court. So once you reach IRS appeals or are moving on to tax court, you're in litigation territory. You can represent yourself in appeals or tax court, and also a CPA or EA can represent you in appeals and sometimes in tax court if they've passed a special exam. Having an attorney who understands tax law, negotiation strategy, and court procedure is invaluable. There are very good CPAs and EAs who can represent you in appeals and tax court. But generally speaking, what I've found is that as an attorney, I spend most of my time knowing tax law, negotiating with the IRS, and making legal arguments. Whereas just your standard CPA is going to spend most of their time preparing tax returns and looking at numbers. And there's nothing wrong with that. But you really need to find a professional to represent you who knows how to make legal arguments, because at this stage we're talking legal arguments, knows how to develop and present a case to the IRS, because it can mean the difference between success and failure for your case. And the seventh and final red flag is IRS Criminal Investigation contact. So if you or your client receives a visit from IRS Criminal Investigation, you should definitely stop everything and call an attorney immediately. Don't answer questions, don't try to explain. Criminal Investigation Division, they don't investigate civil matters. They only handle potential criminal tax violations. So, like you've probably heard on Law and Order or other TV shows, anything you say can and will be used against you in a court of law. So this is one of the most serious tax matters you can face, and it definitely demands immediate legal representation. So those are some red flags to watch out for, but you don't necessarily have to wait for disaster to strike. Sometimes proactive consultations make sense. One of those times is, say, you or your client discover unreported income or unfiled returns, especially ones involving international issues from prior years. The IRS has some voluntary disclosure programs which can help you get current with the IRS while still minimizing penalties and possibly criminal or other tax issues. Or even if there's just unfiled returns, sometimes it makes sense to have a consultation with an attorney before you go through the whole process. Also, if you're involved in a complex transaction with tax uncertainty, so say you're structuring a major transaction like a business sale, a merger, reorganization. If there's any sort of aggressive tax positions or areas of uncertainty, having an attorney review the structure and advising on it can provide valuable insight and possibly defense against penalties. And while I don't represent clients, on the transactional tax side, going through mergers or reorganizations, I see and think about things from the IRS perspective, how they would challenge it, and I can advise on the risks of each position and how it could potentially play out in an audit or court of law. And finally, if there's an IRS audit with the potential for escalation. So not every audit needs to be handled by an attorney. CPAs or EAs can do a great job managing audits with the IRS, especially because they're more familiar with the return since they've prepared it. But if you're going through an audit and signs that, it's expanding beyond just routine verification, questions about intent, requests for business or personal records that seem outside of the scope of the audit, or possible mentions of referrals to other divisions, especially criminal, you definitely want to loop in legal counsel because there could be more at stake than just this one tax return audit you're working on. So for CPAs watching this, I want to emphasize that bringing an attorney doesn't mean you're out of the picture. I've found that the best outcomes happen when CPAs and tax attorneys work as a team. Oftentimes, here's how it typically works. So the attorney handles communication with the IRS, manages legal strategy, and ensures that there is attorney-client privilege. The CPA is going to provide crucial technical tax expertise, help analyze the numbers, and they'll often continue to handle the compliance aspects, preparing returns. That's something I don't do. This is called a Covell arrangement when it's done properly. It's named after a famous case, but it allows CPAs to work under attorney-client privilege when assisting the attorney in providing legal advice. Otherwise, generally, conversations with a CPA aren't protected or aren't privileged, whereas generally communications with an attorney are subject to attorney-client privilege, which means they can't be disclosed. So generally speaking, for you as a business owner, your CPA and your attorney should be regularly collaborating to give you the best possible outcome for your case. And one of the final points I want to make is that oftentimes I get clients who come and ask about costs. Many people think attorneys are expensive, and that's true. Legal representation, especially very good legal representation, costs money. But here's a little bit of a reality check. If you're facing, say, the fraud penalty, that alone is a 75% penalty on top of any tax the IRS claims you own. Trust fund recovery penalties can be an assessment of hundreds of thousands of dollars against you personally. Criminal tax evasion, that can result in prison time and loss of professional licenses. The cost of bringing in an attorney early is almost always less than the cost of penalties, interest, and other consequences that could result from going it alone or with inadequate counsel in a serious tax controversy. So it's almost like insurance, but you get immediate tangible value. And here's something else I like to point out is that fee arrangements can be flexible. For example, many tax attorneys, myself, I'll offer an initial consultation free of charge just to see if we might be a good fit to work together and whether you truly need my services, because it might be that a CPA or another professional can do the same job for a lower price. But when you work with me, oftentimes I do things on a flat fee basis, meaning you pay a set fee for representation and you know what that is up front, or a hybrid or contingency fee basis. This means contingency is based on the outcome. So oftentimes in, say, situations where involving penalty abatement or litigation, I'll use contingency fees to align our interests, meaning when I save you money or you get money back from a refund, I get paid based on a percent of that. So you only end up paying a larger fee when you get more benefit. It's really a win-win for both parties. You don't have any risk if something doesn't work out, but if we do, you're happy and then I'm happy because we earn a contingent fee. So let me leave you with this. If you're a business owner or a CPA and you've come across any of the red flag notices I mentioned earlier, or you're dealing with a sensitive tax situation that might escalate, don't wait. The earlier you get proper representation, the more options you have. Tax controversy is a specialized field that combines both technical tax knowledge with litigation skills and strategic negotiation. When the stakes are high or the IRS claims you owe a bunch of money or there's criminal tax issues on the line, having the right team in your corner makes all the difference. So thanks so much for watching, and I will see you next time with more tax controversy tips.